Hi, so for this video, we are going to distinguish intent from motive. Again, I am using the same reference, the book of Luis B. Reyes and Judge Abudiente. So, motive is the moving power which impels one to action for a definite result, while intent, on the other hand, is the purpose to use a particular means to effect such result. So, as a general rule, criminal intent is sufficient as an element of a felony. But in certain specific crimes, it is necessary to prove specific intent, it being an element of a crime, and has to be established by the prosecution in order to convict the accused of a crime charge. So, intent to gain must be proven in the crime of theft, while intent to kill must be established in frustrated or attempted murder or homicide. Otherwise, the accused will be convicted only of physical injury. So you can use conception, you can use the case of conception versus people on this. While motive, on the other hand, is not an essential element of a crime, and hence need not be proved for purpose of conviction. So one may be convicted of a crime whether his motive appears to be good or bad, even though no motive is proven. So a good motive does not prevent an act from being a crime. So in mercy killing, the painless killing of a patient who has no chance of recovery, the motive may be good, but it is nevertheless punished by law. So when motive, so when relevant and when not to be established. So we have four here. So first is the identity of accused, second, antagonistic theories, third is no witnesses, and the fourth is circumstantial evidence or sufficient evidence. So first, we have identity of accused. So generally, proof of motive is not essential to pin a crime on the accused if the commission of the crime has been proven and the evidence of identification is convincing. So where the identity of a person accused of having committed a crime is in dispute, the motive that may have impelled its commission is very relevant. So motive is essential only when there is doubt as to the identity of the assailant. It is immaterial when the accused has been positively identified. Where the defendant admits the killing, it is no longer necessary to inquire into his motives for doing the act. So while the question of motive is important to the person who committed the criminal act, yet when there is no longer any doubt that the defendant was the culprit, it becomes unimportant to know the exact reason or purpose for the commission of the crime. Then where the identification of the accused proceeds from an unreliable source and the testimony is inconclusive and not free from doubt, evidence of motive is necessary. Now let's go to antagonistic theories. So motive is important in ascertaining the truth between two antagonistic theories or versions of killings or versions of the killings. Then the third one is no eyewitnesses. So where there are no eyewitnesses to the crime and where suspension is likely to fall upon a number of persons, motive is relevant and significant. So the case, example for relevant case for this is the People versus Milgar 157 Escra 718725. And the last one is circumstantial evidence or sufficient evidence. So if the evidence is merely circumstantial, proof of motive is essential. So proof of motive is not indispensable where guilt is otherwise established by sufficient evidence. Now let's go to how motive is proved. So generally, the motive is established by the testimony of witness on the acts or statements of the accused before or immediately after the commission of the offense. Such deeds or words may indicate the motive. Now let us proceed to motive proved by the evidence. So example, appellant stabbed the deceased. It was established that there are two suffocating smokes noticed during the progress of the religious service of the Iglesia ni Cristo, which made appellant to go around. Certainly, the causing of those smokes, presumably by non-members, which disturbed and interrupted the service, particularly at the time when the minister was preaching, is enough motive for any member of the sect to be offended thereby, particularly appellant who was a member of some importance. This is from the case of People versus Ramirez, 104 Phil 720-726. Now let's go to disclosure of the motive is an aid in completing the proof of the commission of the crime. Thus, the fact that the accused had been losing in their business operations indicated the motive and therefore the intent to commit arson for the purpose of collecting the insurance on their stocks of merchandise. This is from the case of U.S. versus Go Fu Soy, 25 Phil 187204. But proof of motive alone is not sufficient to support a conviction. So the existence of a motive, though perhaps an important consideration, is not sufficient proof of guilt. Mere proof of motive, no matter how strong, is not sufficient to support a conviction if there is no reliable evidence from which it may be reasonably deduced that the accused was the malefactor. So even a strong motive to commit the crime cannot take the place of proof beyond reasonable doubt, sufficient to overthrow the presumption of innocence. So proof beyond reasonable doubt is the mainstay of our accusatorial system of criminal justice. So lack of motive may be an aid in showing the innocence of the accused. So in the case, the Supreme Court concluded that the defendant acted while in a dream, and his acts with which he was charged were not voluntary in the sense of entailing criminal liability. So under the special circumstances of the case, in which the victim was the defendant's own wife, whom he dearly loved, and taking into consideration the fact that the defendant tried to attack also his father, in whose house and under whose protection he lived, besides attacking Tanner and Malinaw, his guest whom he himself invited, as may be inferred from the evidence presented, the court finds not only lack of motives for the defendant to voluntarily commit the acts complained of, but also motives for not committing said acts. So lack of motive to kill the deceased. By the way, that case was the case of People versus Tanyo, 58 Phil 255257. So the lack of motive to kill the deceased has been held as further basis for acquitting the accused, where the lone testimony of the prosecution witness is contrary to common experience and therefore incredible. So that ends my video. So Thank you for watching.